Hello everyone, this is Jasmine and welcome back to your channel Lawpedia. So आज हम करने जा रहे हैं part 3 of your judgments yearly review video of 2020, and today we'll be covering certain family law judgments that have been given by the Supreme Court in the year 2020. So this would be a relatively short video because there are only few judgments that we need to look at, and so we'll be wrapping up this. In the next video, we'll be taking up civil law judgment delivered by the Supreme Court of India in the year 2020. Let's quickly move forward to our first judgment, which is Aishwarya Pulsalkar versus Maharashtra Housing Development Authority and others. So, इस important judgment में discuss हुआ था wife's right to reside in the matrimonial home can't be enforced against the development authority or the builder. So, in this case, it was stated that a wife's right to reside in her matrimonial home does not flow from the Maharashtra Housing and Area Development Act 1976. Therefore, it can't be enforced against the builder or development authority. In the case, the matter of debate was an appeal filed by a woman seeking right to reside in the homes allotted to her husband under the Maharashtra Housing Area Development Act. What happened in this particular case? In this case, appeal was filed by a woman having strained relation with her husband and in-laws. The woman in this particular case was stating that she has a right to reside in the house allotted to her husband under this particular act. And ये उसने enforce की against the builder authority or the development authority. Now, court stated that builder's obligation was only to the extent of accommodating the original owners in the redeveloped portion. That means whenever we are taking the accountability or the responsibility or the extent of obligation of the builder, उसकी obligation कहाँ तक होगी? The builder will have an obligation only up to the first owners for whom they are selling. They'll not be having any obligation towards the wife. A woman married to the owner's family can't enforce her right to matrimonial home against such builder. So court ने basically ये state किया कि if you are claiming the right to residence in this particular house as a matrimonial home, then you're claiming it as a status of a wife, and you cannot thus enforce it against the builder or the development authority. You have to go and seek relief in the proper family court or the civil court, and you cannot enforce such a right against the builder. So that was the basic judgment delivered. Let's move on to the next case. The next case is Satish Chandra Ahuja versus Sneha Ahuja. Again a very important judgment, जहाँ पे कोर्ट ने reinterpret की the definition of shared household as defined by the Protection of Women from Domestic Violence Act 2005. So what happened in this particular judgment? इस judgment में court stated the definition of shared household given in section 2S of the act cannot be read to mean that the shared household can only be that household which is the household of the joint family to which the husband is a member or in which the husband of the aggrieved person has a share. In this particular case, court has stated various conditions to be fulfilled for a house to be covered under the ambit of section 2S as a shared household as per the act. Now, shared household meant the place where the woman lives or at any stage has lived in the domestic relationship either singly or along with the husband, and it includes the house owned or tenanted by him. And what was interesting and what was different as in this particular case was court ने ये भी कहा कि the definition of shared household would also include the households which may belong to the joint family of which the husband is a member, irrespective of whether the husband or the aggrieved person has any right, title or interest in the shared household. That means अगर वाइफ एक डोमेस्टिक रिलेशन में अपने हस्बैंड के साथ एक हाउस होल्ड में रहती हैं फॉर अ सिग्निफिकेंट पीरियड ऑफ टाइम, even though husband has no particular interest, no particular right, and even though the wife also has no particular right or interest or title of that particular household, the wife can still claim it to be a shared household under section 2S of the act. And this means that she can seek residence order with respect to the property which belongs to in-laws if she and her husband live there with some permanency after marriage. That means अगर in-laws की भी कोई property है and the wife and the husband are living there for some period of time or for some permanency after the marriage, the wife can claim it to be shared household under definition 2S of the act. एंड हस्बैंड की ओनरशिप का स्कोप भी बहुत डाइल्यूट कर दिया सुप्रीम कोर्ट ने इस पर्टिकुलर जजमेंट में. एंड इन दिस जजमेंट कोर्ट ओवररूल्ड S.R. Batra versus Taruna Batra, a 2007 judgment of the Supreme Court of India, which I would mention in your description box below so that you can go and further read it. Now moving on to another very important judgment, which is your Vineeta Sharma versus Rakesh Sharma and others. From this particular landmark judgment, Supreme Court stated that daughters are now equal co-partners at birth even if born prior to the 2005 Amendment Act to the Hindu Succession Act. Very important, this particular judgment gave a proper value to daughters as co-partners when we are considering the scope under the Hindu Succession Act 1956. Now, court held that daughters have right in co-partneries by birth and that it is not necessary that the father should be living when the Hindu Succession Amendment Act 2005 came into force for the daughters to get a share. सो बेसिकली जो ये अमेंडमेंट आई थी जिसके अंडर डॉटर्स को को पार्सनरी राइट्स दी गई थी प्रॉपर्टी की, दैट मीन्स राइट बाय बर्थ इन द ancestral property. With respect to this, there was confusion that what if the father was not alive when the amendment came into force, that is 9th September 2005, then what? And then court in this particular judgment clarified the question and stated it is not necessary that the father co-partner should be alive as on a date of 9th September 2005 when your amendment came into force for your daughter to become a co-partner. Court in this particular judgment has also stated that the conferral of right is by birth and the rights are given in the same manner with incidence of co-partner as that of a son, and she is treated as co-partner in the same manner with the same rights as if she had been a son at the time of birth. Again, to ensure this decision does not lead up to reopening of the earlier family settlements or partition suits already decreed or decided, the court held that a registered settlement or partition suit decreed prior to 20th December 2004, the date when the amendment bill was tabled in Rajya Sabha, will not be reopened. So this is just to avoid कि ज़्यादा लिटिगेशन ना हो इस पर्टिकुलर एरिया में. सो एक डेट सेट की गई है कि इससे पहले जितनी भी family suits or family settlements decided थे, they will not be further reopened. And finally, daughters like sons have equal birthright to inherit the joint Hindu family property. उसी को elaborate किया था इस particular judgment में. Quickly moving on to our last judgment for this particular video, S. Vanitha versus Deputy Commissioner Bengaluru Urban District. इस particular case में court interpreted two particular sections of separate acts. Okay, so first we have is Section 36 of the Domestic Violence Act 2005. Second is Section 3 of the Senior Citizens Act 2007. Court stated daughter-in-law's right to reside under the Domestic Violence Act cannot be forgotten while we are considering right of in-laws to seek eviction under the Senior Citizens Act 2007. So, इस particular judgment में Supreme Court ने कहा that the Maintenance and Welfare of Parents and Senior Citizens Act has no overriding effect over the right of residence of a woman in shared household within the meaning of the Protection of Women from Domestic Violence Act 2005. Basically, court stated that you should read the two acts in a harmonious manner. So usi ki reading and usi ki interpretation ki judgment is this. It was also stated that the tribunal under the Senior Citizens Act 2007 may have the authority to order an eviction if it is necessary and expedient to ensure the maintenance and protection of the senior citizen or parent. However, the overriding effect for remedy sought under the Senior Citizens Act 2007 cannot be interpreted to exclude all other competing remedies and protections that are sought to be conferred by the Domestic Violence Act. That means while we have given powers to senior citizens under the Senior Citizens Act 2007 to ask the authorities for an order of eviction or to ask the tribunal for the order of eviction for maintenance, still सीनियर सिटीजन इस पर्टिकुलर प्रोविजन को यूज करके डॉटर इन लॉज को एविक्ट नहीं कर सकते एंड डॉटर इन लॉज विल वेरी मच हैव अ राइट under the Domestic Violence Act to the shared household provision. They can very well seek that particular relief. And the right of a woman to secure residence or a shared household cannot be defeated by securing an order of eviction under the Senior Citizens Act 2007. So that's it for today's video. I hope आपको family law judgments clear हैं, and if you are having any doubt pertaining to the judgments or pertaining to the things that we've discussed today, I would request you to please write them down in the comment section down below so that we can discuss over there as well. And as I always say, for any legal help, you can write down to me in the comment section down below. And please subscribe to the channel if you haven't. Click the bell icon for further notifications. And I hope you all stay home and stay safe and keep learning. Thank you so much for watching. Stay tuned for the other videos.